Live from Chattanooga, Tennessee, it's Nuganomics with David Toulis.
Tennessee law is very local economy. It envisions that local people with a grievance against an entrenched good old boy network in a county, in a city, even in the state, can be broken by a chisel. The chisel hit by a hammer, the hammer pounding away, cutting out what could be a cancer, it could be a corruption, it could be a hemorrhoid, as it were, a hemorrhoid cut out by excision, lopped off by the action of a small group of people acting under the power of the statute and acting, in fact, on relation of the state. They take the part of the state itself as a committee of a small number of people. We're going to find out how many people are needed to act this way to cut out a lawless actor in state office. And we have with us on the phone Karen Blake. She is an attorney at Baker Donaldson. She's been worked 20 years in municipal law, and was involved in an ouster action in Franklin, one that took some time. She has been working on the question of the democratic process, if you will, the democratic process in which people by a representative group throw out, veto, if you will, a particular state, city, or county, or even a utility actor. Karen, tell us about the relator law. What does it do? How does it empower my listener potentially?
Well, good morning, and first of all, thank you very much for inviting me on your show. I'm happy to explain that the state statute under Title 8, Chapter 47, 110 gives the right to 10 citizens of a jurisdiction to try to remove or oust a public official from office only if they can show that there has been some crime, some terrible moral turpitude action that requires forfeiting that office. And I think it's important to mention that the 10, all they need to do is to file a statement under oath, and they also, by a separate statute, get the right to ask their city attorney or their county attorney for assistance.
So these are the statute envisions that the people filing this action of grievance for corruption or crime or malfeasance are common people. They don't have legal experience, and they might not even have the means, if they're commoners, to afford an attorney, even if they're massed as a group of 10.
Correct. We even have a case as late as 2010 and an Attorney General's opinion talking about it in 2013 that say basically they just have to be citizen plaintiffs, no more. And very often it's pled that they are interested and they live in that jurisdiction, and that's pretty much it, assuming as they fit the citizen definition and are probably over 18 and are in that area. So they really don't need much more to prove much more than that to constitute that group. Now, very often, working with a city attorney or a county attorney, you'll see typically more than 10 listed just in case somebody moves. So, for example, in the case that was heard back in 2010, it happened out in Knox County, and they had 16 people. So that's always a good idea.
Well, tell us, give us a sense of how this works in Knox County. Karen Blake of Baker Donaldson, what happened there?
Well, there's basically a case. First of all, I have to mention that, there are a lot more of these ouster cases than what are reported. What that means is that all throughout the state, you'll have filings and trials at the local court level in state court that will never sort of see the light of day and never be reported. So we really can't have a good sense of every single type of case. The only kinds of cases we get to read about as attorneys and lay folk that are available to us are whatever that goes up on appeal. And appeals are usually rare. So when they do, they usually have very good points of law that need to be argued. So the one case that I found late was back in 2010, and it has pluses and minuses, but basically what happened in that case is you had 16 plaintiffs file an ouster suit against two particular commissioners alleging that they had removed money, misappropriated public funds, and that one of them had gone outside and tried to hire secretly a private attorney to appoint 12 new commissioners. So basically, the lawsuit alleged that there were violations of the Open Meetings Act, among other things. And at the very end of the case, the 16 were successful as to one of the commissioners who had tried to hire the private attorney, but not successful as against the other.
So you had, all right, just to clarify, Karen Blake, there were 16 citizens or residents of Knoxville. They sued against a was it Knoxville, Knox County, or Knoxville, the city, in the case?
Knox County commissioners.
So they were county residents.
Mm-hmm.
And how was it that the county commissioner was ousted? When was it the judge's ruling? Was he the finder of fact? Was there a jury in that case?
In this case, there was one of the questions whether or not they were entitled to a jury, and the trial court below found that the plaintiffs were not, but the appellate court said, you know what, you are entitled to a jury. So that was one of the issues on appeal. So these things can go to a jury, but more often I would say that the judges will often hear the case, and things tend to settle out even before it gets too far.
And the man who's the defendant would probably rather have, if he's a political figure and he's being accused in a political context, he probably would favor a judge being finder of fact and law, because juries are open to emotional appeals and inflammatory arguments.
That's a great point. Yes, the judge could hear it for those reasons. But then again, the flip side of that coin is we have an attorney general's opinion that sort of voices what I think you may hear the judiciary feeling, that and very often, and the standard is that once you have to prove this kind of wrongdoing to a certain degree of, clear and convincing evidence, and that's a legal standard. And what that means is your group has to show, not beyond a reasonable doubt like you have in criminal law, and not more likely than not as you would have in civil law. Those are the two other standards. But
that's the preponderance of evidence standard.
Something more than it's more likely that this crime had occurred. And keep in mind, it's not necessarily that the crime has been fully prosecuted yet. You may just have allegations, in which case the proper local authority, that would be either the city attorney or, in Knox's case, the county attorney, would be obliged to go forward and investigate the case by law. They have a duty by law to investigate, and then if the evidence rises to a clear and convincing standard, then they must file suit for an ouster. So
let's say the crime in view is one that would be a statutory crime, such as private inurement of using county money for your own building a pool in your own yard or something like that. That would be a crime. Yes. So theoretically, the state actor, the public officer, could have two cases against him. One by the citizens with a kind of a hybrid standard burden of proof, ousting him from his office. The second one would be a prosecutor who represents the interests of the state prosecuting for a violation of a statute or a crime of corruption, perhaps. So
that's exactly right. That's exactly right. And, it may be that the city attorney holds off, or the county attorney holds off until the DA prosecutes the case to see if there's, then you would know that there was reasonable, beyond a reasonable doubt standard had been met, which is higher than clear and convincing. But danger with that is, well, if they don't prevail, then the question is, can you prevail on the clear and convincing standard if you follow?
Right. So go ahead.
Go ahead. No, I'm fine. It's just that it does take a little bit more. And the reasoning behind that, if you look at what some of the attorney general's offices have said, is that, this involves ousting someone. It has to involve something so serious that couldn't be corrected by just the normal democratic process of votes, voting through the next election cycle. It's got to be so severe that you don't trust that person and that they've committed a knowing and willful misconduct in office such that you can't trust them to be there any longer. It's not simply, well, we don't like this guy and we should have not, we should have voted in another person. That clearly would not be a good reason for an ouster. The reason would be it's an official dereliction of duty. It has to be drastic. Otherwise, the courts and the Office of the Attorney General are very reluctant to overthrow the will of the people as shown in the ballot box. But what you were talking about here as a very pro-democratic process is that something happens after they're elected, something serious, and it's against the public's interest to continue to have that person in office because it's so egregious. So you have to draw that distinction.
Well, what I've come into this question, Karen Blake, attorney with Baker Donaldson with offices in Nashville and in Chattanooga. I've come into this question by looking at the relator law and particularly the oath of office that county clerks take to uphold the Constitution. Right. And I have suggested at least once here on my show and at least once as a writer at Nuganomics.com that county clerks who obeyed Obergefell, the opinion in June from the High Court, they are involved in something which is scurrilous and injurious to the people, namely violation of oath of office. They are making a false record to record two men as having been married in their county, which also, I would say, offends the perjury statute. And fourthly, that they've acted in bad faith because they know when they took office that the Constitution of Tennessee controls, and not any opinion anywhere else. And so the question there is, how would you evaluate a scheme of that kind that would oust a county clerk for malfeasance in office, for obeying the High Court's opinion or ruling, as it's called?
That's a great question, because for such a long time that particular issue was up in the air, and you had opinions on either side. You had circuit courts on either side, and until the Supreme Court took a look at it, there were many folks who were uncertain under the law as it stood. So you have to remember that this ouster statute, once again, has the knowing and willfulness standard. If they knowingly and willfully disregard the law as it is, they may not like it, but as it is, if in any situation, if they are going against what the highest court in our land has opined, and any Tennessee law as well, because they take both a Tennessee and U.S. Very often oath to uphold the U.S. and Tennessee constitutions. If they are willfully disregarding, those laws, then they will have a situation where 10 people can allege that they are not fulfilling their duty. On the other hand, when something is not as clear, not completely decided, or it's in process of being decided, whatever happened at those times, it's arguable that they were not willingly and knowingly, committing any sort of offense by taking the advice of what typically is their county or city attorney. Usually these public officials will ask, their respective attorneys what they should do, how they should do it. And so long as they follow the advice of that attorney, very often they are protected individually. But that's not to say that someone couldn't oust them if they could prove that there was indeed a crime that was committed.
Well, let's just pretend for a second that Bill Knowles here in Hamilton County, who capitulated to Obergefell the day it was published, let's say there's a committee of 10 that seeks to oust him for violation of oath, false recording, and perjury. His defense is, well, there's no willfulness because of Obergefell being an opinion of the High Court. I can't be willful because I took that opinion into account. Is that his defense? Is that how he can rebut the accusation of bad faith?
That may be one way, and that would be something that when he gets, he or she, I'll just say in that position, someone in that position would hire their own counsel. Let me be very general first and move to the specific. They would hire their own counsel, and they would look at their options as far as what, and try to show that they were following the best advice of their attorneys. And at that point, that may be another area that is a defense, though it's not a named defense in any of the statutes. It's just at this point something that's never really truly been argued, but that I'm aware of in Tennessee. However, I think the 10 citizens, once they would put forth that a law has been violated willingly and knowfully, in that situation, they would have a greater chance of prevailing with the more evidence that they have that it's clear and convincing.
But the thing that the relators, the citizens like my listener and the 9 other people, they are facing a defense. Okay, and that defense would be, well, Bill Knowles, the clerk, he may have violated his oath of office, but it doesn't matter that he did, because the SCOTUS opinion, the opinion of the high court, voids the law, voids the oath at that point. The law is not living anymore. Therefore, there is no law to uphold. He can't be said to have violated the Constitution, which has been extinguished, deleted, voided, and destroyed by the opinion. That's his defense.
That would be his defense. And maybe there are others that I haven't really thought of yet, but it's a really great question because there are perhaps some other methods, other theories under which a prosecution could go forward other than the ouster statute. And that would provide that person with some other defenses, but I'm not sure if it would work, those defenses, in an ouster statute. It's a very interesting question.
This is David Toulis. We're talking with Karen Blake, an attorney with Baker Donaldson. She's been 20 years in municipal law, and she's kind of a specialist in the questions that deal with conflicts and ethics among attorneys. She is she's often engaged to be the attorney's attorney when there's a question of an officer of the court, the attorney having a conflict or a potential conflict or an appearance of conflict, dealing with a case or a client or a conflict in court. Well, all right. So, Karen, in sum, then you're saying that the relator statute is very democratic. It enables common people like my listener, if he can gather enough support locally, to claim a violation of law by a state actor at the county level or the city level.
Well said and perfectly said. That's a great summary.
Well, we do thank you for your time, Karen Blake. Thank you for joining us.
Anytime. Please call me anytime.
Yes, thank you.
Thank you very much.
This is David Toulis. We've been talking with Karen Blake, who is an attorney. I found out about her from the work of David Fowler. David Fowler from the Tennessee, the family group in National Fact, the Family Action Coalition of Tennessee. And he apparently has looked, as I have, at the relator statute, in which you, my listener, and at least 9 other people, can form a committee and take on yourselves the mantle of the state itself. You are called a relator because you sue on behalf of the state and on relation of the state. You are the party bringing the grievance. You're sort of the carrier. You carry the grievance from Hamilton County or Chattanooga to the state, and then you represent the state itself, turn back upon your target, the man who's violated the law, who's maybe corrupt or evil or a malefactor, and then you sue him in a process that the court has to address immediately. And the time frame for these relator suits is very, very short. He has 20 days to answer. You get in line first. The judge has to rearrange his entire docket to get your case in. Your case goes in first. So the question is there a grievance in Hamilton County? Is there a grievance in the county in which you live? If you are elsewhere in Tennessee, do county clerks have a duty to uphold the Constitution?
Leon, let those boys have a bud.